old. I never seen any teenager being kept in such a shit conditions as my son, both in Wayfield and in Sunlight Center. It is extremely distressing situation for my son, and there is no need to be qualified guardian to realize what extreme emotional harm was brought to my child within, okay? And respectfully ask you to fulfill your duty and to work at the best interest of the child, not of interest of local authorities.
Yeah, I think there's quite a lot there. Let me kind of respond back, if I may. A couple of things. In terms of you making any protests and things, I mean, I'm aware.
Right. Yes, please. Yeah. Okay.
Thank you. In terms of what you're wanting to do in terms of any protests and any issues that you wanted to raise, I'm aware obviously there are injunctions in place. I would advise you not to break those injunctions, but obviously it's up to you in terms of how you wish to pursue things, and it's not for me to say what you shouldn't or shouldn't do. And I understand if you feel that's the way you need to go with things, then you're entitled to make that decision. I suppose all I could say to you in terms of the Guardian is to say that obviously I wouldn't want you to do something that was either breaching any of those agreements or putting yourself at risk of any kind of penalties and stuff. I recognise from your perspective, and I think you said this to me before, you're now at the stage where you don't care, or you're not, you're willing to do what it takes, I suppose. And if that means, putting yourself at risk, you're prepared to do that. I think that's probably a fair summary, really, from your position in terms of, how you see things. Now, in terms of the application itself, now obviously the application before the court, and I can only consider that application before the court. I can't consider what's happened before in terms of the care application, which happened last year, and the reasons why Justin is in local authority care. But obviously the proceedings concluded last year, and I know that those are proceedings that you don't agree with, and I know that those are proceedings where you feel the judgments weren't correct by the courts. And in fact that Justin should still remain in your care, and I understand your position in that respect, but the reality at the moment is obviously your son is accommodated, he is under a care order to Medway Council, and that's the situation, that's the kind of the reality of the situation that we find ourselves in at the moment. Now, in terms of your current application, you've made an application for an increase in contact. You're saying that you're not happy with the current level of contact being offered to you by Medway Council. Now, obviously, Medway Council have provided evidence in relation to contact notes which appear to indicate there have been difficulties in contact. Now, I know, again, you dispute that, and of course, I think, as I said to you previously, it is your right to call those contact supervisors to court and to cross-examine them if you feel that in any way, their opinions or their recordings are erroneous in any way, or that there are any I suppose, if you feel there are factual inaccuracies or issues which you say, because obviously at the moment, the picture I have as the Guardian is there are some concerns about the nature of contact. Now again, I do recognise you don't accept that, and of course, you will, I'm assuming, cross-examine the contact supervisors about that because you feel they've made decisions or recorded things that are incorrect. And in terms of my position as the Guardian, I'm hoping Colin Dearmer, the child solicitor, made it clear at the last hearing that I will be coming to observe a contact between you and your son, because obviously you're saying to me, or you said to me, that actually the recordings of the local authority don't reflect, from your opinion, how things are at contact, and that too much store has been put by certain issues that have been raised, which you think have been kind of blown out of proportion, really. So I will come and observe the contact in July and have an opportunity to see you with your son and to get some sense from my perspective as to how I feel you are and how you're interacting with your son. So,
Mr. Cooper, I have no any illusions about your views, and you know perfectly well that 3 times contact has been stopped on the reason that I merely try to discuss with my son UN Convention of Children's Rights. I raised this issue in Strasbourg. It is absolutely despicable, right? This is one thing. You're also perfectly aware that I got criticism for my last contact because my father called from Israel, 84 years old, and he shouldn't have done it because I didn't get a permission. This is an act of absolute and utmost cruelty, and I know you're covered by your authorities, you're covered by the judge, you're covered by everybody, but you have to understand, you're not covered from the general public view. So before we are starting to even to discuss about this evidence of a supervisor, may I ask you, have you ever thought how my son feel about this decrease of a contact? Have you ever asked him whether he feels something dangerous in those contacts? Have you ever asked him how he would feel if his grandfather, who he hadn't seen for a long time, my son is not allowed to read court judgment? I want to remind you that my son not allowed to discuss his human rights, and I'm going to bring on a Contact Children Act. You have to understand, it's only a matter of time. General public will know it, and you and others will be named and shamed in this issue. All right, that you have to be aware. But now, no, I don't want. Now the question is very, very, very simple. I'm coming to the basics. I consider this room of a sunlight not in the best interest of the child. There will be me, you, Justin, supervisor, interpreter, minimum 5. I don't know whether social worker will come or not, but minimum 5 people. It is extremely, sorry? She's not coming. It's minimum 5 people. So